clicked it, and then I think when you gave it to me, maybe lost your recording ability. Okay, I think we're recording now.
Yep.
All right. Perfect. Well, welcome. Some of you recognize some names and faces from last time. So our second presentation this month with the Senior Center, focusing on power of attorneys. Today, as you'll obviously, if you can hopefully all see my screen, is focusing on the durable power of attorney or financial power of attorney. So my name is Jackie. I am the supervisor here with Fond du Lac County Aging and Disability Resource Center. I've been with Fond du Lac County just about 8 years, doing multiple positions here, transferred to the supervisory role last year. So I have Stephanie with me, and I'll let her give her a little introduction.
Hi everyone, I'm Stephanie and I'm the newest case manager here at the ADRC. I started here about 6 months ago now. September will be a year, but very familiar within working with the field. So that's it.
There we go.
Short and sweet.
That's perfect. Okay, so now I'm gonna hit the next slide and pray that it goes. You guys are seeing the next slide, I hope. Okay, so just we forgot to do this last time, so we're remembering this time. Our little disclaimer, we are social workers, case management by our profession, so we are not attorneys. We are just giving you information, how kind of we present information or would interpret information in our roles and what we've seen. So the information in the presentation and what we'll kind of go over is based off of a GWAR do-it-yourself packet. So GWAR is Greater Wisconsin Agency on Aging Resources. So they have a lot of wonderful tools and information that people can use. And so Stephanie, thank you. Stephanie was able to pull a lot of that together for this presentation. And I think just our additional disclaimer is we are not experts. We will try and answer your questions as best we can. We do know about financial power of attorneys, but I would say, at least for my comfort level, is more specific to the healthcare that we talked about last time. But we do still have enough knowledge to at least kind of teach you guys the basics specific to the financial one. Okay. I'll let you get going then, Stephanie.
Okay, so basically an overview of having a durable power of attorney. So of course it's important to plan for the future when it comes to making your financial decisions when you're no longer able to do so, and choosing somebody who's going to manage your financial affairs in the event, again, that you're not able to manage those yourself. So the state of Wisconsin legislator had created a document that that you're able to utilize to name agents to manage your financial affairs. And that, again, that form would be the Wisconsin statutory power of attorney for your finances and property. The state form is the only one possible tool for financial planning, and it's not always appropriate for everybody. So in instances where you don't feel that the state form is applicable to you, you're able to consult with an attorney and draw one up through working with an attorney in regards to your finances and property.
And I think that you'll hear us kind of talk about it throughout, but that is really one of the big differences between thinking healthcare and finances, is depending on how much property someone has, how many different types of assets they have. There's a lot more specifics that may need to be included in a financial document than the healthcare one. So for some people, it really is easier to go through that attorney. Like Stephanie was saying, we'll probably reference that several times throughout. So what exactly is a financial power of attorney? It's a document that the terminology is the same as with the healthcare document. So a principal would sign and name an agent. Typically we use the verbiage agent versus attorney in fact when we're talking, but to help manage your finances. So the state form is available online. We also have copies of it if anyone would need. But like we just said, if you have very specific assets or real estate, or there's a lot of nuances maybe within finances, it is sometimes better to consult that attorney to complete the document, depending on what your needs are.
And so when does the agent become, effective? So the big difference and the keynote to keep in mind between the healthcare and the finances is, as soon as you create the durable power of attorney document that the state has, it automatically takes effect. So you don't, unless it's specified otherwise in the documentation, or if it's not specified at all, it does take effect immediately. So you're not waiting until you're found incapacitated to that you're no longer capable of making decisions. Again, taking effect immediately unless specified otherwise in a special instruction section listed on the document, or in the paperwork that your attorney might draw up, stating that you don't want it to become activated or effective, I should say, until you are found or deemed incapacitated. And then the state will follow the guidelines in regards to their definition, which is defined as the inability to manage property, finances, or business affairs because the individual meets the following criteria, which would lead us into our next slide.
Yes. So the incapacity criteria are just a little bit, it's not really different from the healthcare power of attorney. There's just additional provisions within this one. So obviously that first bullet point, the inability to receive and evaluate information or communicate decisions determined by a physician or psychologist, that's going to be similar to your healthcare one. But then there's also the extra provisions, maybe not they're missing, not able to be located, detained, or outside of the United States. So there's a couple extra bullet points on this one that the healthcare power of attorney does not have. I think the big thing to point out is at the bottom of the slide, that even if you have it be effective immediately, that does not say you're not going to manage your own finances or do anything, or you're giving the agent full authority. It's just meaning they can act right away unless you specify otherwise. But just keep in mind that you always would retain that right to be able to handle your personal affairs as far as finances go, as long as you have the capacity to do so.
So determining if your power of attorney for finances is durable and what exactly that means. So the term durable means that that the elected agent has the authority to start making decisions on your behalf, even if you become permanently or temporarily unable to do so for yourself. So the state form is automatically a durable power of attorney form, making that effective immediately, and again, unless specified otherwise. And then it remains in effect even if later on down the road you meet that incapacitation criteria that we just reviewed on the previous slide. So completing that power of attorney document allows you to choose the specific individual that you want making your financial decisions on your behalf. And it's really important to discuss with that person your plans, your wishes, so they can continue to act on your behalf in accordance to what you would want, if you should no longer be able to do so for yourself.
Okay. What happens if you don't complete the document? So as with the healthcare power of attorney, if there would come a situation where you would become incapacitated and unable to manage your finances on your own, there would maybe be no one with legal authority to take over managing those things for you. So you could potentially be looking at maybe needing a petition for a guardian of a state to appoint someone to manage those finances. And again, it's kind of difficult that even if someone is married, depending on what type of asset it is, the spouse may not have authority to act on any of those assets. So although Wisconsin is a marital property state, it means if a home is owned by two people and would need to be sold without a document saying that it could be done, or an alternate decision maker could make that choice, there's a lot of legalities with being able to do some of those things. So even if you're on, well, we're on each other's bank accounts, or I'm their spouse, is sometimes enough in some situations, but not all situations. So it is still important to name that alternate decision maker should there be a situation where you're unable to make those decisions for yourself. This slide does give examples of some necessary transactions, which again, depending on if it's a joint account with a spouse, may not be an issue, but it could still be an issue. And then talks about the potential of maybe needing to go through the guardianship process unnecessarily if there is no financial decision maker appointed. One thing that isn't really talked about in here too, but is an option sometimes that we see if an alternate decision maker is not appointed, where someone is incapacitated and didn't do this document, we sometimes see what's called a representative payee, but that is very specific to, maybe just Social Security, being able to manage that Social Security, or you can assign a representative payee with some like pensions to manage a pension, but it's going to be very specific with what that payee can do. And it's not really going to give them authority to, sell things or, set up accounts. There's very limited authority with that representative payee, but I just wanted to point out that that is sometimes the route that goes depending on what a person has for finances and assets.
So different ways to complete the form, to complete the power of attorney for your finances and properties. So option number one would be, again, to hire and retain a lawyer to assist in drafting a document that is specific to what you are needing or wanting. You may, choose to use the state form that's free to you and accessible online. We do have copies here at the ADRC office. However, as we said in the beginning, we do not provide any sort of legal advice or specific financial related questions. So if you are stopping in to pick up a copy, please know that we would not be able to assist in completing that document with you. But, just giving you some general overview as we are today. You can also obtain a do-it-yourself packet at the GRAR's website. It's not recommended that you obtain a generic power of attorney for finances offline because of the validity issues that it raises in the state. So it may not meet the state statute, making it a formal legal document to be recognized here. So it is important to either consult with that attorney or utilize the state form that could be found online, going to the DHS of Wisconsin's website, or that GWAR website that we referenced previously.
Yeah, and I think that's just the same as when we talked with the healthcare. If you're utilizing it offline, Wisconsin statutes lay out, very, very specifically the provisions that need to be included in the document. So making sure you're using a trusted source so it's not going to be an issue later. Okay, so what factors to consider in selecting an agent? You will see this several times. There are about 3 slides on this specific topic. Trustworthiness. So someone that you can trust. Obviously, healthcare decisions are very important decisions too. But when you give someone the authority to help manage financial affairs, you really want to take into account that trustworthiness piece. Someone who's going to manage your finances really how you would manage them. Not that there are things that, being utilized and that's not really how you managed your finances all of your life. So really someone you trust. Unless in the special instructions section, you say you want some kind of oversight of that power of attorney, there really is no rules that they, there are some rules like in not spending it on themselves and things like that, but you need to put in special provisions because there's no oversight by anyone unless you state otherwise. And really who's going to monitor that can become an issue too. So at the end of the day, really just choosing someone that you trust and having those conversations is important. Will they be asked to gift money to people? And will they have enough ability to be able to say no? Sometimes there are family dynamics where maybe one person is asking for money, and is that person going to be able to say, no, this is not your money, we're not helping you with that, we're not going to do that, that's not the purpose of my role as the agent. So will they follow your wishes and plans? Are they a good financial manager of their own finances? That's a good thing to think about too. Like if they aren't very good at keeping their own self afloat and paying their own bills on time, might not be the best choice for you to pick. This one's always a kicker. Do they live close to you? They don't have to live close to you, but sometimes with bill pay or, if there are any kind of negotiations that need to happen for any new accounts or getting an apartment or anything that you may have to pay for, are they going to be able to come to those things if it were to be necessary? And you'll see then underlined, do you trust them? And then the last slide on here is, and this is a biggie. We are housed with our Adult Protective Service unit. So second to self-neglect is financial exploitation. And unfortunately, we do see financial exploitation happen even if someone has named an agent to do so. So ensuring that you've picked someone you trust, they understand how you manage your finances and how you'd like them managed moving forward is very helpful. The document does, depending on how it's completed, have some protections for you in there. But that's why this one can be tricky, and you'll see so much throughout that even GWAR sometimes recommends more the attorney to help do it, depending on how complicated one's finances are. So if you don't have anyone you would trust, then you probably shouldn't just list someone to list someone, and then run the risk that if a time were to come that you were not able to manage those finances, then you could go through the 2 court processes, either through conservatorship or guardianship. So the difference between conservatorship and guardianship would be that conservatorship would be you voluntarily giving up, saying that you don't want to manage your finances, and guardianship would be really that court order after you've been deemed incompetent. So conservatorship sometimes happens if maybe there just comes a point where you can't do it anymore and you didn't pre-plan for the power of attorney. But those are options in the future, just a little bit more costly than doing the financial form.
So what are your agent's responsibilities and duties as their role as your power of attorney agent? They should avoid conflicts of interest act in good faith, really upholding your wishes as in regards to your financial matters. They should act with diligence, being proactive, in bill paying, because of course, if you've always been, on a timely bill payer, and then you elect somebody that has poor time management or whatever the case might be, you definitely don't want that to be a reflection on you and your financial situation. So making sure that they're diligent, they're timely, meticulous and organized, that they can keep good record keeping. So should you need to have a conversation or should they need to follow up on something, they have good record keeping of what was, purchased or what was sold. So especially when it gets to, to the point where you might need to be applying for Medicaid, and having to turn in certain verifications to the Moraine Lakes Consortium agency, that person would be able to turn in that verification to, account all of your financial related matters. And they should really focus on helping preserve your assets and your estate planning for as long as possible in the best interest of you, not that they're withholding, selling the house because they want to retain, whatever funds from it. If there's inheritance involved, but really trying to preserve your monies for as long as possible, so you are able to afford care, so you are able to afford, your basic means, and just basically overseeing, your property and the maintenance, and even, assisting with tax preparation, and again, that eligibility for benefit programs.
And I think I'll just add in, we talked in the beginning, obviously, that the form would take effect as soon as it's drafted. But obviously, some of these duties are, as long as you are able to do them, you would continue doing them. It would just give this person authority to do them if you couldn't, or if you wanted them to, or if you needed their help. But certainly, if you are able to do these things for yourself, you can keep doing them for yourself.
Mm-hmm. So electing co-agents. So it gets a little tricky when individuals start wanting to elect more than one person, to act as their co-agents when making a power of attorney document in regards to finances. So as discussed in our first presentation when it came to healthcare, it was, we discussed electing like a secondary to act if that primary couldn't act for you. In regards to the power of attorney for finances, electing two agents, they both would take over and have authority. So ensuring and then considering whether or not you really need more than one agent to handle your financial related matters. And then considering, well, what happens if they don't agree? How are things going to be worked out? What is the final outcome going to be if those agents aren't agreeing on how your financial, how your finances need to be managed or followed up on, or anything like that once you're no longer able to. So if you choose and you're wanting to elect co-agents, it's really strongly suggested that you consult with an attorney in that situation.
Mm-hmm.
Because and I just want to add too, working with an attorney, if you are wanting to elect two co-agents or more than one agent, perhaps then they can specify and kind of come up with, what's this agent going to be responsible for? What's that other agent going to be responsible for? So they're not, so there's a little bit of separation in their authority. So again, just consulting with an attorney in regards to that.
Okay, so do I have to pay this person for their duties? So statute allows what's called reasonable compensation for agents. Unless you specify otherwise, they can reasonably compensate themselves for their time. There's no specific as to what reasonable compensation would be. It's just so that it would be within, probably the way that it would be viewed is that what it would cost you to maybe pay for any kind of financial planner or financial assistance time, kind of, is it matching what the going rate for some of those services may be, is how that could be looked at, but it would really just depend on the situation. So if you specify that they are not allowed to compensate themselves, that would have to go in that special consideration section. And this slide kind of lists some concerns if they would be compensated. But really reading that bottom line, if you don't want them to be entitled to compensation or want to set specific limitations on how much that compensation is, then the special instructions section can be used. So the state form does allow some space for special instructions, and then you can obviously add attachments to it, which I do think we talk about in a minute. But it's not very long for some of those special instructions. So that's where, sometimes the attorneys can draft extra pages. And that really just depends, again, on how complicated someone's financial affairs may or may not be.
So how can you protect your assets and your finances and your property against abuse from an agent? So again, really important, picking a person you can trust to make sure that they are managing your finances appropriately. Some other ways you can require your agent to be bonded. You can prohibit and limit gifting within those special provisions and instructions, limiting personal and family maintenance provisions, requiring your agent to send regular updates to you in regards to your accounts and your monies, checking in on a regular basis as well, asking your agent to meet with your lawyer if you go that route to better understand their duties and their role as being your delegated agent, and to make sure that they clearly understand your expectations. So definitely having that conversation with them, and perhaps with that attorney to really review what exactly they have authority over, and clarifying any discrepancies during that meeting or conversation. And then including a statement from your agent within your document and requiring them to sign the important information for agent's duties form that's included in the state form packet. So then who can you contact if you should have any questions? So of course, consulting with an attorney. To find an attorney, you can look online. There's several different ways to look up and retain an attorney. Looking online, looking in the yellow pages, perhaps asking friends for referrals if they've utilized an attorney to help assist with their power of attorney document. Or you can always call the state bar, Wisconsin, and they have that phone number listed there in order to obtain and find an attorney that would help you. The Wisconsin Guardianship Support Center, which is operated by the Elder Law and Advocacy Center, which is that GWAR term that we've been using throughout our presentation to help answer questions related to powers of attorney when it comes to financials and property. And then the contact information listed here below is for that GWAR. Again, that Wisconsin Guardianship Support Center.
And like we said in the beginning, we can answer general questions. This is what the form requires. But really we can't give a ton of specifics or complete the form because sometimes there are so many very specific things that people have. If you own multiple properties, have life insurance policies, there's just so many different nuances with finances. If you have relatively easier to maintain a state, not very many accounts or, different things that the state form may be enough. But if you have a lot of different assets and things, then it's helpful to go through that attorney. Okay, so this is just an extra little piece of knowledge from like kind of what we see and here is specific to maybe some different adult protective services cases with financial exploitation. So what we hear sometimes is, well, I don't really need to do the financial power of attorney document. I have my daughter on my account at the bank, so she helps me pay my bills. And I think that's great in some cases, again, especially if you maybe don't have, that might be the only account that that person has, which is fine. But the difference between utilizing what the bank may call a power of attorney or agent and the financial power of attorney form is that if you have an agent on your checking account at X bank, whatever bank it may be, that is the only account that person could manage, or whatever account you maybe have them on would be the only account that they could manage. So that would mean they couldn't potentially set up any new accounts or really pay bills outside of utilizing that account. It's not really giving them as much authority, which in theory sounds great when you think about it. But like if there were to come a point where maybe you needed to apply for Medicaid or change a health insurance and aren't able to do so for yourself because you don't have the actual financial power of attorney document done, just having that person listed at the bank is not going to be enough to qualify for some of the other financial things that can come up. So that's just kind of a clarification. And then the other thing that we see is, well, I did a joint account with my my child. I did a joint account with so-and-so, and they're helping me manage my money that way. We very much encourage against joint accounts unless it is someone you can wholeheartedly trust, or maybe or is your spouse. The reason we don't like joint accounts is when there comes a point of potential mismanagement of funds or misuse, and it's a joint account. There's very little that we can do, that law enforcement can do, because when it's a joint account, it's equal access by both people listed. Whoever's listed on that account, equal access. So if Stephanie and I have a joint account, and she's helping me pay my bills out of my account, and I'm the only one putting money into this account, but she's just helping me, she can freely take as much out of that account as she wants without ever having to put anything into it. So our recommendation when people ask would be to, obviously you can consult your attorneys, but it's really either to do the agent through the bank on the account. That's going to give you a little bit of protection, or really having the financial power of attorney document with those special provisions listed is going to give you a little bit more protection too, versus doing that joint account. So again, it is completely up to you. That's just kind of our side of cases that we've seen where it's been concerning because it is a joint account and does limit what we can do to potentially either just stop the abuse or try and get any money back is a little bit more difficult. So that's just our APS nod to why another reason it would be important to have the documents done. So Stephanie did provide a great link here, which we can always put in the chat if we need to get the copy of the state form. And then also, again, most of this information is developed from GWAR's do-it-yourself packet and general power of attorney information. So the GWAR information is on there too, if you guys want to explore that and learn some more. So that's really all we had. I guess I don't see anything in the chat, but we'll let anyone who maybe has a question or wants clarification on anything, now would be time to ask. Or if we maybe didn't cover something you were hoping to hear. I think she just said no questions and I can't see the other two, but okay. Well, I hope that you found this helpful. Like we said in the beginning, we obviously more so deal with the financial power of attorney just because there are a lot more intricacies into finances. Oh, and someone did. Vicky said thanks. So no questions from Vicky. Okay, good. Well, we want to thank you guys for attending today and listening. Thank you to the Senior Center for having us. It's been great to talk with you guys this month about both the financial and healthcare power of attorney and really the importance of pre-planning and doing these advanced directives. So thank you all.
Yeah, thank you.
All right, I'm going to stop my share. And Kathy, can I stop the recording or do I have to make you a host?
We can stop.